Dental Practice Risk Management through Regulatory Compliance. Part 7, Texas State Board of Dental Examiners Rule 108.2, Understanding and Implementing Fair Dealing. Hi, my name is Boyd Shepard, and I am a Clinical Associate Professor in the Department of General Practice and Dental Public Health here at the UT School of Dentistry in Houston. I receive no financial benefits that would create a conflict of interest or restrict my independent judgment with regard to the content of this presentation. At any time while viewing the video streaming course, you can take a break by simply pausing your computer. At the completion of this section, you will be asked to take a short exam in order to complete the requirements for this streaming video course. At the time, you will receive instructions regarding taking the exam. Dental Practice Risk Management through Regulatory Compliance Part 7. Texas State Board of Dental Examiners Rule 108.2. Understanding and Implementing Fair Dealing. This online course is designed for dental practitioners to gain a greater understanding of the Texas Dental Practice Act and the rules and regulations of the Texas State Board of Dental Examiners, specifically TSBDE Rule 108.2, Understanding and Implementing Fair Dealing, so that they may implement the appropriate changes and systems in their day-to-day practice that ensures regulatory compliance with these rules and laws. Through understanding and implementation, the participant will also be managing the risks inherent in modern dental practice. Upon the completion of this course, the participant will review, understand, and be able to apply the relevant provisions of the Dental Practice Act and the TSBDE rules and regulations. Be able to apply Texas State Board of Dental Examiners Rule 108.2, Fair Dealing, the focus of this presentation. Value ethical and legal approaches to clinical dentistry in your own practice. And review and implement the risk management procedures and protocols that will prevent patient complaints to the Texas State Board of Dental Examiners. Okay, let's get started. Dental Practice Risk Management through Regulatory Compliance Part 7, TSBDE Rule 108.2, Understanding and Implementing Fair Dealing. It is important to have an overview of the functions of the State Board of Dental Examiners for Texas when studying and learning the rules that regulate your dental license. The Texas State Board of Dental Examiners performs 3 primary functions. Number 1, licensing of dentists and dental hygienists. Number 2, annual registration of all dentists, hygienists, and labs. And number 3, enforcement of Texas laws regulating the practice of dentistry. Also important is understanding where you find or can access the law that regulates your dental license, your hygiene license, or your lab certification. In other words, where in the world does one find the rules? The rules and the laws and regulations of the Texas State Board of Dental Examiners, the Dental Practice Act, and all of the laws that regulate your license with respect to the State Board of Dental Examiners in Texas can be found at the TSBDE website at this URL, tsbde.texas.gov. You can get to this website by simply putting Texas Board Dental or Texas Dental Board into any search engine, and the first link that comes up will be the link to the State Board website. On the home page for the Texas State Board of Dental Examiners, there will be a link that specifically says in the top menu bar, Laws and Rules. And as you click through these links, you'll be able to access the law that regulates your license from the Texas State Board of Dental Examiners. There, you'll find the Texas Dental Practice Act, part of the Occupations Code. You'll also find the Texas Administrative Code provisions for the dental board, wherein you will be able to locate the board rules that we are discussing. You'll also find board policy statements. The best example is the State Board of Dental Examiners policy statement with regard to Botox. Also, you'll be able to access the board's webpage where they answer frequently asked questions that they receive at the board. And also, you'll be able to access, download, and utilize the legal forms that the State Board either requires or recommends use of in your dental practice to be compliant. Please take notice. New rules are always being proposed without notice to you. It is very prudent and diligent for you to check the Texas State Board of Dental Examiners website and check it often. You should bookmark the State Board of Dental Examiners webpage as a favorite in your browser, with instruction to your staff, who should also be taught how to access this information. Also, you can subscribe to the Texas State Board of Dental Examiners newsletter at this email address, newsletter@tsbde.texas.gov. New rules that can affect your day-to-day practice, your day-to-day systems, and your day-to-day interactions with your patients, as well as amongst your office staff, can be and will be not only proposed but passed and become law, and this all can be done without notice to you. The obligation is on you to follow the State Board website and take note of any new rules that are either proposed or passed that affect your license. On the State Board of Dental Examiners website, you can access these newly proposed rules through a link on the top menu bar. There you will find not only specifically a link for new rule proposals, but then an additional link that will take you to the proposed rules, which fluctuate and rotate over time. Here you will find recent rule adoptions. These are rules that were once proposed rules, but because they have been deliberated on, edited, and finally accepted by the State Board through a full board vote, they have now been passed and adopted as rules and regulations of the State Board of Dental Examiners. Unless you actually attend a full board meeting, you would not otherwise know about these new rule adoptions. Again, all of this is easily accessed by a simple search on or within your favorite web browser search engine. Knowing that this is how we access the laws and rules on the State Board of Dental Examiners website, we will now go to the rules, looking for Rule 108.2. by going to the Laws and Rules link on the State Board of Dental Examiners menu bar on their homepage, clicking Laws and Rules, and this will then take us to specifically the page that has the links for the rules. One of these two links has the rules in a black and white text that mirrors the way that you would see it in a law book. The link that we're going to click will take us to the rules formatted in a way that's a lot more user-friendly and for viewing online. You're looking for Chapter 108, specifically professional conduct. However, as we look at this particular slide, you will notice that the State Board of Dental Examiners rules are divided into separate chapters, and each of these separate chapters, as they are defined or labeled or titled, will give you an idea of what these different chapters deal with. We will be dealing with 108.2, Fair Dealing, which falls under the section or the chapter Professional Conduct, Chapter 108. If you have any questions that would fall under any of these other chapters, for example, Chapter 114, Extension of Duties of Auxiliary Personnel for Dental Assistants, or Chapter 115, Extension of Duties for Auxiliary Personnel, Dental Hygienists. These are going to be the chapters and rules that deal with what is proper and legal for the delegation of duties to either dental assistants under Chapter 114 or delegation of duties to hygienists under Chapter 115. When we're looking at Rule 108.2, here in a few moments, there will be a part of that rule which will refer us back to either Chapter 114 or Chapter 115, as the case may be. This is where you see the different chapters separated and titled accordingly. So, in Chapter 108, Professional Conduct, if we click that link, we're taken to a subchapter, Professional Responsibility. You will notice there are 5 subchapters under Professional Conduct, and these are the 5 chapters. Just a side note, you're going to want to take a look at Subchapter B for Sanitation and Infection Control, also as a risk management due diligence. And please make note of Subchapter E, Business Promotion. Even though we'll be in Subchapter A, looking at fair dealing under 108.2, a lot of that discussion has to do with business promotion, advertising, marketing, and there's an entirely separate subchapter that deals with business promotion under this Subchapter E in Chapter 108. Okay, so Chapter 108, Professional Conduct, Subchapter A, Professional Responsibility, Rule 108.2, Fair Dealing. This is how the rule appears online on the Texas State Board of Dental Examiners website. Even though this slide has print that is far too small to study and look at here, the intent of showing you this slide is so that you will see and understand what it looks like online, that obviously you can increase the magnification for to be able to read the rule. The other thing that I would point out on this particular slide that you will notice is the source note at the bottom of the rule. In any given rule of the State Board of Dental Examiners, you will see this source note, and the source note is the notes that gives you the date that the particular law or rule became effective with respect to regulation of your license. This particular rule only has one date, but there are several rules that have multiple dates where the rules are edited over time. Another example of why it's important for you to check back for board rule proposals and rule adoptions, because the editing or the changing or the renewal of any particular rule also has to go through the proposal and adoption process. And what you may understand now about, for example, Rule 108.2 today, within the next 6 months to a year may change, and new subsections of this rule may be added, and the existing subsections may actually be clarified, and those changes may affect the way that you promote your business and affect your day-to-day practice. So again, I reiterate and emphasize, always check back with the state board website by simply going to the board proposed rules as well as recent adoptions. That's the best way to keep track of any changes in the rules that may affect your license. Rule 108.2, Fair Dealing. Subpart A. The dentist has special knowledge which a dental patient does not have. Therefore, to avoid misunderstanding, the dentist shall advise a patient before beginning treatment of the proposed treatment and any reasonable alternatives in a manner that allows the patient to become involved in treatment decisions. Looking at this subpart A, the state board is making the statement in the beginning that says that from the state board's perspective, in their work to enforce these rules in the best interest of the citizens of the state of Texas, they are declaring that from their point of view, the dentist has special knowledge which a dental patient does not have. In other words, the state board considers the dental patient to be at a disadvantage with respect to the special knowledge that a dentist would have with respect to dentistry. Therefore, to avoid misunderstanding, the dentist shall advise a patient before beginning treatment of the proposed treatment, of any reasonable alternatives, and do so in a manner that allows the patient to become involved in treatment decisions. Breaking down this second part of this part A, subpart A, the goal is for the dentist to avoid any misunderstanding on the part of the patient. An effort to work to avoid any misunderstanding on the part of the patient, this rule requires the dentist to advise a patient. It does not say the dentist may advise a patient. It states that a dentist shall advise a patient. And anytime you see the word shall or must, then it is an obligation and it is the law. It's a legal requirement under Rule 108.2 Fair Dealing for dentists in Texas to advise a patient of the following items. And these following items must be stated or advised to the patient before beginning treatment. This advice to a patient cannot be given concurrently with treatment, nor can it be given after treatment, but specifically it states that a Texas dentist shall advise a patient before beginning treatment of the proposed treatment and any reasonable alternatives in a manner that allows the patient to become involved in treatment decisions. If you have reviewed Rules 108.7 and Rule 108.8, you'll recall that in Rule 108.8, in record keeping, that it is a requirement as part of the record to have a treatment plan. It also states in Rule 108.8 that as part of the dental record, you are required to have not only the proposed treatment or treatment plan, but also the options that are, or alternatives that are available for any given treatment. So this information, this proposed treatment and reasonable alternatives are not only required under Rule 108.2 fair dealing, but these items are also required under Rule 108.8 as part of the record keeping requirement. With respect to Rule 108.7, it becomes a requirement in the sense that the items listed in Rule 108.8 for record keeping also become the standard of care for recording that treatment pursuant to Rule 108.8. And then finally, all of this must be explained or advised to the patient in a manner that allows the patient to become involved in treatment decisions. This also will remind you of Rule 108.7, standard of care, with respect to the subsection on informed consent. Part of the definition or concept of informed consent is that you are advising the patient of the treatment in a way or a manner that allows the patient to become involved in treatment decisions. This also will remind you of the ethical principle of patient autonomy, which basically states that a patient has a right to be involved in their decisions with respect to any treatment that they may incur. So, taken as a whole, this particular subsection of Rule 108.2 touches on the legal requirements of a treatment plan and the alternatives being recorded in the patient record under Rule 108.8, and also captures the concept of informed consent, which is also part of the standard of care pursuant to Rule 108.7. All of that to say that technically, and I often see in actual board cases, if you violate these particular subparts of Rules 108.7 or 108.8, you may very well also be in violation of Rule 108.2, and the violation of multiple rules can lead to harsher results or harsher disciplinary action with respect to how a board case is resolved. So I'm trying to create or illustrate the close interaction from rule to rule and the overlap or dovetailing of concepts, in this case Rule 108.2 with respect to Rule 108.8 and Rule 108.7. Subpart B. At a minimum, such advice shall include. So this Subpart B is referring back to Subpart A, advising a patient of the treatment plan and any reasonable alternatives in a manner that allows them to become involved in treatment decisions. Subpart B is saying that this advice shall include at a minimum, and then lists these 4 sub-items that at a minimum this shall be discussed or disclosed to the patient. It does not say may, it doesn't say you can think about it, but rather the rule requires at a minimum that this advice include the following. Number 1, the nature and extent of the treatment needed by such patient. So, you have to advise a patient of exactly the type of treatment and to what extent the treatment will exceed to as recommended by you, the doctor. Number 2, the approximate time required to perform the recommended dental treatment and services. So this may be news to you as you're reviewing the requirements of this rule. It's not typical, in fact I would say it would be highly unusual for a dentist in Texas to record in their notes any proposed approximate time required to perform any recommended dental treatment and services. Now, Rule 108.2 doesn't say anything about record keeping. It doesn't say anything about any of this information being written down in your progress notes with respect to treatment. However, there are certain requirements in Rule 108.8 that are aligned with this Rule 108.2 with respect to the information or advice that needs to be recorded in a dental record. I refer you to Rule 108.8 for that. You will not see in Rule 108.8 any requirement of the discussion about the approximate time required to perform the recommended dental treatment and services. However, I do advise from a risk management perspective that you find some shorthand way of notating not only the treatment proposed and the alternatives proposed, but also the approximate time required that you've advised the patient. For example, a crown prep might take any given doctor 30 minutes, it may take 45 minutes, it may take an hour, depending on location in the mouth, size of the tooth, which quadrant that it's in, any special considerations with respect to the anatomy or the tooth structures that's available. All of that discussion is required to be given to the patient, but also it affects the approximate time required to perform that particular crown preparation. So it would be compliance with this particular rule to not only advise the patient of the approximate time, but in my opinion, just good sound advice from a risk management perspective. Whatever time that you advise the patient, with variation, that you expect the crown preparation in our example to take X amount of time or minutes. This would be good record keeping, and this would go a long way that if there ever was a complaint and you found yourself having to defend yourself, to be able to show that you understood the rules to this level or this detail would go a long way to defending any complaint. Subpart 3, the terms and conditions of the payment of the fee. Now, typically in a dental record, and as required by Rule 108.8, you'll always find not only the treatment plan, but the proposed fees and conditions of payment that have been agreed to between the patient and the dental office. Having this recorded in a particular dental record is usually not an issue with respect to Subpart 3 here. Subpart 4, any further or additional service or returns by the patient or adjustments, repair, or consultation and the time within which this shall occur. So, any follow-up, for example, on, could be our crown example, it could be a denture, it could be any type of partial or any type of prosthodontic care, anything that requires a return appointment, even for a consultation, needs to not only be recorded in the notes, but the need for the patient to return for this type of work should be advised to the patient as part of Rule 108.2 fair dealing. In other words, at the beginning or before the treatment takes place, for our example of a crown preparation, you would say, pursuant to Rule 108.2, you would advise the patient before treatment begins that it may be necessary for you to return for adjustments or for a denture delivery. It will be necessary for you to return for adjustments. Anything along those lines, pursuant to Rule 108.2, you are required to advise the patient of this type of information before the actual treatment. If you recall in Rule 108.2 Subpart A, where it says before beginning treatment, right there in the middle of Subpart A. So that includes everything listed here in Subpart B, that the patient needs to be advised of all of this before beginning treatment. Subpart C of Rule 108.2, fair dealing. On the written request of a patient, the licensed dentist shall provide, in plain language, a written explanation of the charges for professional services previously made on a bill or statement for the patient. For this rule, the term plain language means language that avoids terms of art or usage of words having specialized meaning in a context typically understood only by healthcare professionals. So, for the first part of this, Subpart C of Rule 108.2, it specifically says that this information, this plain language written explanation of the charges for the services rendered on a bill or a statement for the patient, that this only is required to be provided to a patient if a patient makes a written request. A written request may come in the form of an email. A written request may come in the form of a hand-delivered note. A written request may come in the form of a letter to the office. But as long as it's in writing, and whether or not it's signed by the patient, I would not put the stipulation that it also has to be signed, because the rule doesn't say anything about the request being signed. It only says that if it's a written request of a patient, the licensed dentist shall provide in plain language a written explanation of the charges for professional services previously made on a bill or statement for the patient. Now, when you think about a treatment plan and you think about the itemization of a treatment plan and the proposed fees for a treatment plan, a dentist may think, well, I've already provided that when I provided a copy of the proposed treatment plan. However, this particular rule is stating a written explanation of the charges and in plain language. In other words, the dental board in this Subpart C of 108.2 is requiring a little bit more than a treatment plan, a little bit more detail, but detail in a way that the second sentence of this subpart, it has to be language that avoids terms of art or usage of words with specialized meaning in a context typically understood only by healthcare professionals. In other words, a plain language, lay person, how we speak to each other way of explaining what the actual charges were for, but no usage of abbreviations and no usage of large dental only type words that the patient will not be able to understand. If you just back up and look at this particular subpart, this is a good example of what the intent of Rule 108.2 is. It is to make sure that a patient is dealt with fairly. It is to make sure that a patient understands the treatment to be rendered and that it's been presented to them in a way that there is no misunderstanding. And it's done at a time that is before treatment begins, and that if they have any question after treatment is rendered or a bill is submitted, that if they provide you with a written request, that then puts the obligation on you, the licensed dentist, to provide a written explanation of the charges. Again, the larger, bigger picture here is to make sure that there's no misunderstanding on the part of the patient and that the dentist has done everything that they can possibly do with respect to fair dealing under this Rule 108.2. Subpart D. Neither the dentist nor his employees shall mislead dental patients as to the gravity or lack thereof of such patients' dental needs. So this subpart of Rule 108.2, fair dealing, captures the thought or the idea that a dentist can avoid misleading or not being completely transparent, or perhaps stating things in a way that guides a patient to make certain decisions in favor of the dentist. A dentist can avoid that and avoid being responsible under the idea or the rules with respect to fair dealing by delegating these discussions or lack thereof to their employees. In other words, any discussion about a treatment plan or the presentation of a treatment plan can be delegated to an employee, and it might be that the employee is the one guilty or liable or responsible for misleading a dental patient. And so the Subpart D is saying, we, the Texas State Board of Dental Examiners, we are going to not only hold you, the licensed dentist, responsible for any alleged and apparent misleading of your dental patients, but we're also going to hold you responsible for if there is a finding that your employees have misled the dental patients of your practice. Now, this particular section specifies misleading dental patients as to the gravity or lack thereof of a patient's dental needs. So any misleading under this Subpart D would have to go to a discussion with the patient about the need for dental treatment, whether or not they're in great need or whether or not they're in no need at all. But in either case, whether or not the statements made not only by the dentist but possibly by their employees as to this gravity or need for dental care, or the lack of the need for dental care, or the lack of the discussion of the need for dental care, whether or not any of that was misleading to the dental patient. Under this Subpart D, it extends not only to the dentist, but it also extends to their employees. This is one of the ways that this particular rule, 108.2, translates also to rules 114 in Chapter 114 for dental hygienists, as well as 115 for dental assistants, and the delegation of duties and those requirements under those rules, the subject of another presentation. Subpart E of Rule 108.2, Fair Dealing. A dentist shall not flagrantly or persistently overcharge, overdiagnose, or overtreat a patient. For this rule, the meaning of the term overcharge includes, but is not limited to, collecting or attempting to collect a fee without reasonable justification for any element of dental services provided to a patient that is in excess of the fee that the dentist ordinarily charges to others for the same service. So, breaking this particular rule down, you have the statement, a dentist shall not flagrantly or persistently overcharge, overdiagnose, or overtreat a patient. And then the rule or Subpart E of Rule 108.2 goes on to define the term overcharge to include, but is not limited to, the collecting or attempting to collect a fee without reasonable justification for any element of dental services provided to a patient that is in excess of the fee that the dentist would ordinarily charge to others for the same service. So, breaking down the first sentence, it is a violation of Rule 108.2, Fair Dealing, to either flagrantly overcharge or persistently overcharge. So this overcharging, which is defined in the second sentence, can either be found to be a one-time event. An event that can only happen one time is enough to violate this rule. And the question will be whether or not the overcharging was it flagrant? Was it excessive? And was it excessive to the extent that it meets this definition of overcharge, where this fee is more or in excess of what is ordinarily charged, and that extra charge or that higher charge is without any reasonable justification. So a defense to the overcharging portion of this rule might be that this particular fee might be in excess of what is normally charged, but there are reasons or there are facts present in this particular case or in a particular case that gives reasonable justification or reasoning behind the charging extra, and therefore it is not overcharging as defined by the rule. If you can show a reasonable justification why a particular patient was charged more than others for the same service, then you have a defense to the overcharging component of this particular rule. But do notice that it's not overcharging, overdiagnosis, and overtreatment, but rather this rule has three different areas where you can violate. One is overcharging, which we've just discussed. The second is overdiagnosis, and the third is overtreatment. So with overcharging, you might present a treatment plan to a patient, and that treatment plan would necessarily have the charges or fees listed and itemized for the treatment to be rendered. And the patient may decide to go and get a second opinion and may in fact have the treatment rendered by a second opinion dentist and never undergo treatment at your office even though you've presented a treatment plan. In my experience, the dental board has violated and brought disciplinary actions against dentists for overcharging even though treatment was never rendered. In other words, a treatment plan was presented where the dentist proposed an intent to charge fees, and the dentists weren't able to show any reasonable justification why they were charging fees that were higher than what they would normally charge to others for the same service. Now, part of this, again, a defense is not only showing reasonable justification, but another defense might be this is not an inordinate fee for this type of service within the marketplace. That might be a defense, but this particular rule focuses on whether or not it's something that you in your practice would ordinarily charge others in your practice for the same service. This is differentiated from overdiagnosis. The fees might be reasonable that are presented in a treatment plan, but overdiagnosis in the sense that there's no clinical justification. There's nothing apparent either in the radiographs or in the clinical examination or a combination of both, or if there's photographs present, it may be found that the treatment plan offered actually offers more treatment than what is necessary or justified in a particular case. This would be considered overdiagnosis and is distinct from overcharging. Obviously, if there's overdiagnosis, then by default the fees would be higher than if there were what would be considered diagnosis within the standard of care. But the fees presented with an overdiagnosis case may be reasonable fees for the treatment that is recommended, but there is more treatment recommended that is clinically necessary. In other words, overdiagnosis. And this is then differentiated from overtreatment. And what makes overtreatment separate and apart is, in this instance, overtreatment is where the patient has actually undergone treatment and can not only capture the overdiagnosis that has now turned into treatment that was not necessary and not reasonably justified, or it can be treatment that was added on during the course of treatment without informed consent or getting the approval of the patient, in addition to not having reasonable justification. I can tell you that looking at this particular subpart of Rule 108.2, that over the years, this is the subsection of this rule that I see violated or alleged in allegations against dentists in complaints, as well as investigations by the State Board of Dental Examiners, is the overcharging, overdiagnosis, and overtreatment portion of this rule. If Rule 108.2 is going to be alleged in any particular case, it's typically this subpart E, or some component of it, overcharging, overdiagnosis, or overtreatment. I can remember a case years ago where Dentrix and other computer programs that are used in the dental office for an electronic health record being utilized started to be used in the marketplace. And a particular doctor was found to have violated Rule 108.2 fair dealing on an allegation and a complaint with respect to not only overdiagnosis but also overcharging, because they presented a treatment plan and used their clinical examination and the examination record that was generated by Dentrix as a tool to make the presentation to the patient that this is work that needs to be done and this is what has been found, and that the computer program would generate a report that had the teeth charting and had red marks everywhere the doctor had indicated that work would most likely need to be done in the future, and that this was misleading to a patient because what the patient understood was that it was treatment that needed to be done now, whereas the doctor was trying to defend on the point that these were items that he foresaw that would need to be done in the future, but it was the patient who understood that the treatment needed to be done immediately, and it was this misunderstanding that led the patient to go to a second opinion doctor. And the second opinion doctor did not have an electronic record program, but basically did a more conventional, old school, no computer program examination, and presented the patient with a treatment plan that had far less treatment recommended that needed to be done currently. And so when you look at the difference between those two proposed treatment plans, the State Board found this first doctor to be in violation of this rule because of the way the information was communicated to the patient. And so the doctor was found to have been in violation of overcharging and overdiagnosis under 108.2 fair dealing. Finally, Subpart F. A dentist may not employ an auxiliary to perform any dental procedure which he cannot personally perform. This particular subpart of the fair dealing rule, as I stated before at the beginning of this presentation, is connected and, in my opinion, better explained, and more details are provided in what is proper to delegate to either a dental hygienist or a dental assistant under chapters 115 and 114 of the State Board rules dealing with delegation to auxiliary personnel. Those rules have to do with what's properly delegated to auxiliaries, and also the fact that, or whether or not a dentist needs to be present, but specifically deals with this particular point, and that is anything that's going to be delegated to an auxiliary cannot be anything that the doctor cannot do themselves. It's a pretty broadly written subpart of the rule. There's not a whole lot of explanation here. It's a part of the rule that I don't think that I've ever seen it alleged. If anything is going to be alleged with respect to dental office auxiliaries, it's usually going to be under chapters 114 or 115 of the State Board rules with respect to dental hygienists and or dental assistants. But do be aware that it could be a violation of this Rule 108.2 as well. So, that concludes our review of Rule 108.2, Fair Dealing. If you need any clarification, if you have any questions about this presentation, Rule 108.2, the explanations that have been given, please send an email to utsdcontinuinged@uth.tmc.edu. This has been Dental Practice Risk Management through Regulatory Compliance, Part 7. TSBDE Rule 108.2, Understanding and Implementing Fair Dealing. The references to Rule 108.2 come directly from the rules as they appear on the State Board website, found at this URL. This completes Dental Practice Risk Management through Regulatory Compliance, Part 7, TSBDE Rule 108.2, Understanding and Implementing Fair Dealing. It is now time for you to take a short exam in order to complete the requirements for streaming video courses. Due to the nature of our subject content, a passing score of 90% is necessary in order for you to pass the course. Upon a successful completion of this exam, you will be visually informed that you have met the requirements to proceed. If you fail to answer enough questions correctly, you will be instructed to take the exam and a new set of questions will be provided. You will have 3 chances to fulfill the requirements. If you are not successful, you will be instructed to review this section again. Good luck on the exam, and if you are ready to take Dental Practice Risk Management through Regulatory Compliance Part 8, Rule 108.3 and Rule 108.11, Displaying of Registration and Consumer Information, then upon the completion of this exam, you will be provided a link to continue. If you wish to proceed at a later date, you will need to log in, and no further payment is necessary since this is a continuum.